Hi, my name is Hank Lee, and I am an associate at BSKB. In December 2016, the Supreme Court decided a very important design patent case that reached the High Court in over 120 years. In the December ruling, the Supreme Court vacated nearly $400 million in damages that Apple Inc. had been awarded after a jury found that Samsung infringed its smartphone design patents. The lower court held that the design patent statute required infringers to pay their total profits from the end product found to infringe, and awarded Apple Samsung's total profits from its infringing phones. Samsung strongly argued that paying Apple its total profits from the infringing phone would make design patents too valuable and would have disastrous practical consequences that Congress did not intend. Samsung's argument was supported by tech industry, including Google, HP, Dell, and other major firms. The Supreme Court agreed with Samsung's argument that when a product has multiple components, patent owners may only be entitled to the profits from the infringing component of the end product. The smartphone war between Apple and Samsung began in 2011 when Apple sued Samsung in California, alleging various Samsung smartphones infringed Apple's design patents covering the rounded corner of the case and arrangement of the icons in the screen of the smartphone. The district court found Samsung must pay its total profits from the entire infringing phones under Section 289 of the patent statute. Section 289 provides that a person who manufactures or sells any unlicensed article of manufacture to which design or a colorable imitation has been applied shall be liable to the owner to the extent of his total profit. Samsung argued that the profit awarded under Section 289 should be limited to the infringing component, like the screen or case of the smartphone, not the entire smartphone when a device has multiple components. The Federal Circuit rejected Samsung's argument and identified the entire smartphone as the only permissible article of manufacture for the purpose of calculating Section 289 damages, because consumers could not separately purchase components of the smartphones. Therefore, the question before the Supreme Court was whether that reading is consistent with Section 289. The Supreme Court held that the term article of manufacture simply means a thing made by hand or machine, and thus encompasses both a product sold to a consumer and a component of that product. The Supreme Court held that because the term article of manufacture is broad enough to embrace both a product sold to a consumer and a component of that product, whether sold separately or not, the Federal Circuit's narrow reading cannot be squared with Section 289's text. The Supreme Court reversed lower court's ruling and remanded the case to the Federal Circuit for further processing to establish how much Samsung must pay under the rulings, which could result in a significant decrease in the damages award. The Federal Circuit's ruling is due June 2017. Thank you for joining me. Stay tuned to bskb.com for more upcoming videos on interesting cases and other commentary on intellectual property. 감사합니다.